Good afternoon. My name is Robert Wolf. I'm with the Oregon Marijuana Policy Initiative. The OMPI is comprised of 14 different medical marijuana advocacy and patient groups representing the vast majority of all medical marijuana patients and advocates in Oregon and directly representing a membership of tens of thousands of people. We're here today to talk about House Bill 3664, which is set for hearing today in the House Rules Committee. OMPI and our constituents object to this bill, both in the process by which it came to be, and we object to the contents as well. The centerpiece of this bill is a requirement for the confidential patient registry to turn over to the Oregon State Police all records of registered medical marijuana growers once per quarter. This is an outrageous requirement given that we have compelling evidence that Oregon law enforcement agencies are already accessing that supposedly confidential database up to 100,000 times per year. OMPI cardholder records are protected by the Oregon Medical Marijuana Act, and law enforcement officials are only supposed to access the database regarding active investigations. Were there 100,000 active criminal marijuana investigations in all of Oregon last year? I say there were not. The law enforcement officials in Oregon have instead been engaging in a systematic, regular, and abusive trolling of the confidential patient registry in order to find out who is smoking medical marijuana and who isn't, regardless of whether they are suspected of a crime or not. These shocking numbers show that Oregon law enforcement is engaging in vigilante-style prosecution against Oregon's medical marijuana cardholders. Without valid reason and in apparent defiance of existing law, they are gathering information about tens of thousands of citizens, including ordinary people who have nothing to do with medical marijuana whatsoever. I think this information is a smoking gun. I think that the provision in House Bill 3664 calling for expanded access to the database is a major mistake. Law enforcement in Oregon needs more respect for the database and the existing law, not more access. I'm calling upon the House Rules Committee to table this bill without any further work and to let it die for this session. I'm further calling upon Oregon's law enforcement agencies to respect the letter and the intent of the law and limit their access to these confidential patient records. Be happy to take questions.
Could you clarify something you said near the end that I thought I heard you say that they're gathering info on thousands of people, including people who have nothing to do with medical marijuana altogether. Can you explain that a little?
Sure. There's two ways they can get data from the database. During the day, they call up and a staff member answers questions and keeps a manual log. In the evening, they can enter a name and address into a database and get a yes or no answer as to whether that person is a cardholder. We have numbers from the medical marijuana program that for a one-year period ending in September 2010, law enforcement accessed the database 51,000 times. I'm presuming that our law enforcement officials are equally as diligent and active during the day as they are at night, and that another 50,000 inquiries occur during the day for a estimated potential high access number of 100,000 accesses per year. There aren't 100,000 cardholders in Oregon. There's only about 40,000 patients. So they are checking the database against a multitude of citizens who have nothing to do with medical marijuana whatsoever. What are they doing with this information? We really don't know. Are they gathering the information and storing it for their own purposes? Some counties have rates of checking the database that are so high, it appears as if they're checking virtually every contact they make against the registry. The biggest abuser is Marion County, who during the reporting period accessed the database over 9,000 times by the Marion County Sheriff's Office alone.
So, I mean, how do you know that, couldn't they be checking some people multiple times? Like, how do you know that it's, more than the number of people that are?
Sure. I can't break it down quite that way, but in the PowerPoint presentation, you'll see some numbers that show that the rate of database inquiries in different counties, especially the counties that are the biggest abusers, far exceed the rate of marijuana or behavioral crime in those counties. And during the entire year of 2010, only 60 people were kicked out of the medical marijuana program for violating the Oregon Medical Marijuana Act. 100,000 potential queries to get 60 people is a gross diversion of law enforcement resources. They should be focusing on solving real crimes.
So where's the harm here? I mean, so they check somebody's name and nothing happens, so what's wrong with that?
There's a couple kinds of harm that can come from that. One kind is that they may be stockpiling this information for other uses. We really don't know. If they are breaking the law and accessing this information for non-medical marijuana people, who else are they trying to gather information on? Another concern, let me think of other concerns and I'll answer that question in a second.
And I mean, so how do they know that they're not a medical marijuana person without checking?
The law enforcement, if they catch somebody or have a suspect at a crime, the crime needs to be marijuana related. And it would generally be a marijuana crime where they're caught and they're saying, my defense for having this product is I'm a card holder. And then they would check to see if that person is a card holder or not. But in some of these counties, they are checking an equivalent of 15 to 20 times per patient in their county.
So, I mean, couldn't that be people who falsely say that I'm a card holder and then they do their due diligence and check and see that they're not?
It could be.
How would that kind of show up?
I don't think that would show up. But let me give you another scenario that's more realistic. And then I'm going to bring Brian Michaels up to talk about other kinds of abuses of the system. We have a lot of anecdotal evidence of officers stopping people for traffic infractions or other reasons, checking the database before approaching the car, and then coming up to the vehicle and saying, you're in the medical marijuana program, let me see your card, and then asking to search the vehicle. Instead, they're supposed to find a crime, develop a suspect, have marijuana involved, and then access the database. Brian, can you address the question about the different kinds of abuses that are taking place?
Yeah, and some of the current concerns resulting from that abuse. I think it's important to understand that when a privacy is engaged by a statute, that privacy is intended by the statute for the protection of the people whose privacy is being protected. And so when there's an exception to that privacy, which there is in this statute, which says that law enforcement may access this private information, then the purpose of that exception to the privacy is going to, as by definition, has to be to the protection of those whose privacy is being protected. So when they allowed the exception to the privacy, they said, look, you're at a house. You know there's marijuana growing in there. We think it's to the benefit of that card holder for you to know that that card holder has a lawful grow site there, rather than you go and get a search warrant, break into the house, and find out he's legal or she's legal. So when they accepted to the privacy, they did it to the benefit of the card holders. So the law enforcement access is only to prevent unnecessary investigations to be pursued, to unnecessary warrants, and potentially unnecessary arrests. Now, when you work into the areas of access for other reasons, you come into what is now two appellate court decisions. The law enforcement decided that it was up to them to access medical marijuana information to determine whether somebody who was applying for a concealed handgun license should have a concealed handgun license. I had a case called Held out of Douglas County where the Court of Appeals said that information is private. Mr. Berger had a case in the Court of Appeals that he won, and this morning he won in the Supreme Court saying it's illegal for you to deny somebody a concealed handgun license because they are a medical marijuana card holder. I bring this up because The reason to access the information was not to the benefit of the cardholder, not to the benefit of the person whose privacy was being protected, clearly to that person's detriment. They accessed that information to deprive that person of a statutory and constitutional right, which is to own guns and have a concealed handgun license. A clear deviation from the purpose of that access. Now, once you can recognize that they are willing to abuse that privilege, why on earth would you expand that abuse? Once they have proven themselves to access that for purposes in direct conflict to why they were first allowed to access that information, why would you trust them to further access that information? But a further issue, I think, needs to be addressed to understand the politics behind this. One, why are they in the medical marijuana no concealed handgun license business in the first place? In my case, I asked the sheriff on the stand, I said, well, how much medical marijuana is too much? He didn't know. So, well, what would be the point of doing that? We don't know. Do you think that they would access the doctor and physician records of people abusing OxyContin or question whether somebody who's getting a concealed handgun license is abusing OxyContin? The answer is no. So there is no legitimate law enforcement interest here. Law enforcement is now pursuing a political interest. That is not their job. Their job is to enforce the law. Their job is not to pursue political, social issues. Which brings us to why are they in the medical marijuana business in the first place? Why on earth is law enforcement inserting itself into the health care of 40,000 Oregonians? There are almost 4,000 physicians who have said this is a good medical benefit for my patient. Why on earth can law enforcement get up there and say we disagree with those doctors? They are wrong. We think there are too many people who have medical marijuana cards. This is not a health care issue in terms of law enforcement. This is a political issue. And I submit when law enforcement is used to pursue political gains, then they have overstepped their bounds of public safety and law enforcement. And they are now entering into a whole different world of picking and choosing who gets to do what health care. Who gets to take aspirin, who gets to take OxyContin, who gets to take medical marijuana. That's not their
Do you have
job.
any more questions for Brian?
Do you have any questions?
I'm sorry, I didn't get your last name.
Michaels, Michaels.
And Mr. Berger, would you be willing to step up?
Well, I want to make one more statement about
Do you have any other
3664.
questions? Okay.
This is the other part of it, Chris. This bill it was developed in secrecy after the several House committees declined to move anti-medical marijuana bills forward this session. Representative Olson took it upon himself to form an ad hoc work group and meet in secret with law enforcement officials over a period of many weeks to craft HB 3664. I asked to be involved in that process. I was not allowed to be involved. During these secret meetings, I sent Mr. Olson a letter offering expert briefings on any and all aspects of marijuana and medical marijuana. The offer was rejected. I then sent Mr. Olson a letter offering up a number of excellent suggestions for improving the medical marijuana program. Those were completely ignored. At that point, we didn't know when the bill was going to show up. We didn't know what was going to be in the bill. And voila, it showed up in Rules Committee last Friday. Rules Committee is the last refuge of the orphan bill that can't get traction in any other committee during the session. And Mr. Olson's the chairman, so he managed to wrangle a hearing. And worse than that, he has limited the public's ability to speak on this bill. Originally, he said he would only allow invited people to speak, and today he loosened that to after the invited speakers, others may speak as long as the hearing on the bill didn't exceed 60 minutes. We object to the secrecy. We object to the backdoor process. We object to the limited public input. We object to the fact that the bill was crafted without any input from the constituents who will be directly affected by this bill. And I'm going to urge the committee to table the bill and let it die.
You've talked a lot about the provisional increasing access to law enforcement access to the database, do you object to the other provisions that would make it more raise the standard for somebody who qualifies for the card?
Yeah, all the different changes have reasons why they're negative. I would say the next worst one is the changing of the standard of care. Now, the last draft I saw changed the standard from may mitigate symptoms to will provide therapeutic value. I find that to be unreasonably vague and an unreachable standard that no doctor, procedure, or pill could hope to meet every time. I believe the uncertainty of that language will result in doctors staying away from the program in droves, making it difficult for some patients to enter the program, even if they desperately need access to medical marijuana. There's also a provision in the bill to cause minors and their parents to recertify their qualifying condition 4 times a year instead of once per year. There are currently 60 people under age of 18 in the program, according to program staff. We're talking about children with such bad disease, such horrible cancer, that their parents are driven to try to get them access to medical marijuana. And we're proposing to quadruple the effort and cost these parents have to bear to get help for their children. I think it's entirely reasonable to protect kids, but there are no 10-year-olds in the Oregon medical marijuana program abusing the system just to get high. This requirement is onerous and unreasonable. Okay. As you know, the Supreme Court decided today that in the pot versus pistols case that the pot wins, or excuse me, I guess they both win. But Leland Berger was one of the litigants in the Held versus the Sheriff of Douglas County case that was decided in favor of the medical marijuana card holder, who now gets to have a concealed handgun license. And Lee would like to make a statement and answer questions. Bravo, Mr. Berger, by the way.
My name is Leland Berger, B-E-R-G-E-R, and I represented 4 patients who were denied concealed handgun licenses. I came by today because of the implications from 3664 that Mr. Wolf and Mr. Michaels have already spoken to. Certainly some of the 50,000 or 100,000, whatever the number actually is, of checking the database have to do with that. And with today's decision from the Oregon Supreme Court, that will end. And we're grateful for that. It didn't involve pot or pistols. It involved medical cannabis, and it involved discrimination against patients, qua patients who were otherwise statutorily eligible for a concealed handgun license, but were denied concealed handgun license under a reasoning that now 12 Oregon judges have rejected. The trial courts in Washington and Jackson County, the 3-judge Court of Appeals, and the 7-judge Supreme Court. The point is, and I think the point of our assembling this afternoon is that as I understand what Representatives Olson and Barker and Krieger are doing is that they're reacting to constituent concerns about abuses within the program. And what we wanted to share with you is what we've found and believe to be an abuse of the program by law enforcement. And I know that Representative Olson, as a former police officer, and he's on record as being especially concerned about abuses it's the law enforcement data system, the LEDS system, that police officers access often with an onboard computer in their vehicle, and often in the daytime. It's just that they can't contact the program at night, and they have to use this onboard computer when the program itself is closed. But the point is that the notion that there are too many card holders, the notion that there are rampant abuses of the system, the notion that the legislature needs to do something to fix it is a fiction. It's not true. The problem with the program is the problem that was left unresolved in last November's election, which is there is a surplus of excess medical cannabis being produced, and there isn't a regulated supply system to be able to get it to the patients who need it, who are unable otherwise to access it. Had we passed Measure 74 last election, we'd have licensed and regulated dispensaries. Instead, now we have unlicensed and unregulated dispensaries. And if the legislature wants to take something on, they ought to take that on. Another positive thing that we've asked them to do, we certainly asked it in the hearing on Senator Cruz's bill, was the program has been reluctant to add any debilitating medical conditions. At the very least, for our returning veterans, we could add post-traumatic stress disorder. This last week, Delaware became the 16th state. 16 states and the District of Columbia now have medical marijuana. Delaware is one of the states that approves the use of medical marijuana by people suffering from PTSD. It's the very least we could do for our returning troops. I did win in court today, but there's another provision in 3664 that seeks to correct the aftermath of a case that I lost. I represented a California patient named Joel Behringer, who was taking his friend Jeremy Fox to Fort Lewis, where Mr. Fox was going to become Sergeant Fox and go to Iraq, and he did, and he's come home safely. But Mr. Behringer was stopped near Oregon City on 205, and he had in his possession his medical marijuana, and he had his California recommendation, because California is not a registry identification card state. Showed that to the policeman who arrested him, took him into custody. He was prosecuted and convicted, and we lost as well on appeal. We claim that it violated his full faith and credit that he was entitled to, and his right to travel. The Court of Appeals said that the full faith and credit wasn't an issue because all the California recommendation does is protect him from California prosecution, and they weren't interfering with that. But on the right to travel, they were concerned about whether the statute, that the application process granted a privilege to Oregonians that it denied to people from out of state. And so they looked at it and they said, well, it's ambiguous whether this is a complete list or not. And so to save the statute from this constitutional attack, we'll find that it is ambiguous and that you could register if you were an out-of-state patient. And in response to that, the Attorney General agreed with the Court of Appeals' determination. The program issued administrative rules permitting out-of-state registration. Both the Court of Appeals, in what lawyers call obiter dictum, so it's not really a holding, but they kind of an aside, said that it doesn't violate right to travel, and the Attorney General agrees with that. But I disagree with that, obviously. But whether it does or doesn't, it's unconscionable. It's unconscionable, and it's a waste of law enforcement resources to interfere with patients from California who regularly come over to Oregon with their medicine and to make them criminals. Because fundamentally, what the Oregon Medical Marijuana Act is about, of course, it's about criminal justice reform and sentencing reform. It's about taking that slice out of the pie of criminality that we all agree ought not be criminal. The therapeutic use of medical cannabis by people and the people who help them by supplying them with it. And So my view certainly, and I know Mr. Michaels and Mr. Wolf's view and the groups that Mr. Wolf speaks on behalf of agree that if there needs to be some change, it's not to expand the authority of police who've already shown that they're acting lawlessly, both in the concealed handgun context and otherwise, and and that there are positive changes that could be made, but as long as Mr. Wolf points out, these meetings are held in secret and they don't invite us to it and they don't want to hear from us, we're going to continue to show up at the legislature to oppose them and to kill them, and we expect to kill the bill today. I'd be glad to answer any questions you have.
How confident are you that law enforcement will basically abide by the Supreme Court ruling today and actually issue these licenses?
Oh, I'm confident that they'll abide by the Supreme Court ruling and issue the licenses. I know that after we won in the Court of Appeals, the woman who was the director of the Southern Oregon Normal went to court when she was denied, and the court ordered that they issue her a concealed handgun license permit, and they did. I think that it's unfortunate that, we have to go to court to get law enforcement to comply with the law. But once we do go to court, our experience is that they, wouldn't you say, Brian?
Oh, yeah. They, in the Held case, which was whether or not they could access the medical marijuana information in the first place, and the Court of Appeals said they could not, the Douglas County immediately gave him his handgun license, and several other people from Douglas County called me, and when I called the sheriff, they said, "Don't worry, we'll give them handgun licenses." And I told them if they didn't get their handgun license to contact me, and none of them did. So
it's an interesting point that you bring up. In conversations with my friend and colleague, in some ways, it is sort of like the ending of segregation in the South. In some ways, there is this resistance, at least emotionally and intellectually, on the part of law enforcement to this change in the law. It's really challenging to distinguish between a bag of pot and a bag of therapeutic medical cannabis. They look the same, but this one is a crime and maybe a felony depending on the quantity of it, and this one is not. Unlike, here we are 50 years after the Freedom Riders. I saw on OPB a show on that. It was pretty dramatic. It was right around this time of year, 50 years ago. But unlike the Freedom Riders in the South in the early '60s, there isn't the need for any state agency, including the courts, to call out the military to enforce its judgments with local law enforcement. I don't get that we're at that point.
Does anyone have any sense of how many people might now, as a result of this ruling? I mean, is there sort of a backlog of medical marijuana patients who have been wanting to get this license? But
I'm not sure the answer to that question. I occasionally got calls, and I would tell. But the thing of it is, we've been winning. I mean, we won in the trial courts, and we won in the Court of Appeals. And when I don't know what you were doing, but when I got calls, I would tell them to call and say we won, or go to court, or you file a petition and there's a hearing. That's the procedure. Well, the concern I have is that the opinion suggests that it's part of the function of local law enforcement is to enforce federal law, and that because it's a federal crime to possess a firearm if you're using an illegal drug or if you're an addict, that somehow Oregon law enforcement could arrest people on that federal charge. Well, the U.S. Attorney, Dwight Holton, is on record standing by the memo that was issued from the Department of Justice that urges U.S. attorneys in states that have medical marijuana acts to not interfere with patients or their providers who are in compliance with the law. Mr. Holton, I know, has some concerns about the Medical Marijuana Act, but he's not going to start prosecuting patients who are possessing firearms who are in compliance with state law on the theory that they're illegal drug users or addicts. I mean, and I encourage you to call him and ask him, but I bet you that's what he tells you. I certainly intend to call him and ask him. So I think that there may be a concern on the part of patients in applying for concealed handgun licenses, especially if they're allowed to continue to ask those questions about whether you're a patient or not. Because of that portion of the ruling. Does that make sense?
Yeah.
Did you have any other questions?
No, I got it wrong.
All right. Well, thank you very much.
Thank you.
Thanks, Chris.